Tim, you got a thumbs up for me or something? All right. All right, welcome everyone. I will call this meeting to order of the Civil Law and Data Practices Committee. Today is Tuesday, February 2nd. We do have a quorum present, and we have two bills on our agenda today. First up is Senate File 193 from Senator Benson. I'd like to ask if Senator Anderson would be willing to move Senate File 193 to be recommended to pass and placed on general orders will be the motion. But if Senator Anderson, if you'd be willing to make that motion.
Thank you, Mr. Chair. So moved.
All right. Thank you, Senator Anderson. Senator Benson, your bill is now before us. Please feel free to begin testimony on your bill.
Thank you, Mr. Chair. The PSYPACT, as this is referred to in its abbreviated form, allows the practice of psychology across interstate lines through telemedicine and limited in-person, temporary in-person, face-to-face psychological or practice of psychology for 30 days in a calendar year. And members, as we've gone through COVID, telehealth has become increasingly commonly used. This was moving before the urgency of telehealth, but I think some of the examples that we've had in our own families and among especially college students traveling back and forth can give us an indication of how important something like this could be to continuity of care. Let me see, so access to care. It is supported by the providers and the Board of Psychology. I'm sorry, members, I'm fumbling a little bit because I'm going to get right to the business. Your jurisdictions, Article 9, Article 10, and Article 12. Let me begin with a quick review. Article 9 is the Coordinated Licensure Information System, and I know this committee also has a great deal of interest in data. It requires uniform data submission. It authorizes the establishment of a database administrator, and if there's an adverse action against someone's license, all the compact states would be notified of an adverse action by a single state against that individual's license. We can still retain some control over this data by designating information as non-public, and we know that valuing the non-public or public status of data is very important. Article 10 establishes the Jurisdictional Compact Commission. Each state that is represented on that commission will have a position, or each state that adopts a compact will have a position on that commission. Let me flip to that. The principal office is in Georgia, and it's important for you. The jurisdiction would be the federal court that is associated with the state of Georgia, or wherever, if the compact should move, wherever that physical office would be. Let's see, I'm moving to the section that was raised. There is a specific concern that has been raised, members, on page 19, line 29, about qualified immunity, defense, and indemnification. I'd like to remind members that this is limited to the scope of the commission's authority and responsibility. It doesn't apply across the state to all of our citizens. And the third article of jurisdiction is Article 12, the oversight, dispute resolution, and enforcement. Courts give notice. And again, I'll remind you that this jurisdiction, the jurisdiction for this compact would be the state of Georgia, the U.S. District Court encompassing the state of Georgia, or if for some reason the compact would move states, would be whatever federal court oversaw that state. With that, members, I think those are your areas of jurisdiction. We do have supporters of the bill here, and Mr. Sands ready to answer legal questions. And so I'm happy to take your questions or refer them as needed.
Thank you, Senator Benson. And yes, I neglected to mention, as you did, the sections, Articles 9, 10, and 12 are what is pertinent to this committee. It's already made a stop, I believe, in your committee, Senator Benson, on the healthcare side of things. So we'll try to limit our comments to these 3 articles of the bills. And we'll get to the list of those that would like to testify. And I will start with Mr. Sam Sands. Thank you for being here today. Please identify yourself for the record and then feel free to proceed with your testimony.
Thank you, Mr. Chair and members of the committee. My name is Sam Sands, and I'm the Executive Director of the Minnesota Board of Psychology, and I am testifying on behalf of the board in support of Senate File 193, or PSYPACT, as I'll probably refer to it during this testimony. I'll try and keep my comments as brief as possible out of respect for the committee's time, and I'm happy to answer any questions that the committee may have for me. The board's mission is to protect the public through licensure, regulation, and education to promote access to safe, competent, and ethical psychological services. The PSYPACT does support the board's mission to provide these services to Minnesota, to regulate the provision of those services to Minnesotans. PSYPACT is an interstate compact created in partnership with the Council of State Governments, National Center for Interstate Compacts, which is a nonpartisan center that helps draft compacts for healthcare, licensing compacts, as well as various other compacts. 16 states have adopted this particular psychology interstate compact, and the bill is partially telepsychology, specific language, and then with the jurisdiction of this committee, also melded with more general compact and commission related language. I did note Senator Benson mentioned the qualified immunity language, and I would just say that much of the language in this compact is consistent with other compacts that the state has passed, approved in the past. Consider the medical licensing compact has similar qualified immunity provisions and for the commission. The 16 states have adopted it. The Minnesota Board of Psychology fully supports the adoption of the compact as written. And let me just briefly touch on the 4 ways that that this bill would support the board's mission. Protection of the public allows us to make sure that competent psychologists are practicing into the state. It provides some more visibility to who is practicing in the state. Currently, we have a provision that allows for 30 days to practice within the state without becoming licensed in Minnesota. Individuals with e-passport, which is what they would get if they decided to enter into PSYPACT, would have to notify us that they were coming to provide services into Minnesota. And that is the other thing, the point that I would mention is that this is an optional thing for our licensees to enter into to enter into this, get this e-passport so they can provide services to other states. And it's optional for psychologists in other states to get the e-passport. It's not something that would be required of our licensees. They could avail themselves of it. It increases access to care. We have a shortage in mental health care and psychological services even during the best times, and that's been exacerbated during the pandemic. And this allows qualified psychologists in other states the ability to rapidly offer services into Minnesota during a pandemic or any time of emergency that we might have that would remove some barriers to getting licensed in Minnesota just for that short time period. It provides continuity of care for business people traveling into the state who want to see their psychologist while they're conducting a business visit here in Minnesota. or as Senator Benson mentioned, the college kids that would be able to continue to see their psychologist from their school. The legislation provides mechanisms for the board to expel or discipline psychologists practicing into Minnesota without a license. Currently, the board has the ability to get an injunction against a person who's practicing without a license. PSYPACT would give the board more tools consistent with what we have for licensees in the state in terms of discipline, referring them to discipline, and protecting the public to make sure that they are practicing competently in the manner that Minnesota expects our psychologists to practice. In addition to that, we can revoke their authority to practice in the state, and we can recommend that the commission revoke their e-passport, which would prohibit them from practicing in any compact state. With that, Mr. Chair and members of the committee, I'll thank you for your time. I'm happy to answer any questions that you may have for me, and I hope that you support Senate File 193.
Thank you, Mr. Sands. If there aren't burning questions, I'll go through our testifiers and then take questions from committee members all together at the end. But if you do have one that you want to interject, feel free to raise your hand and we can take those. But otherwise, I will move to our second testifier, Dr. Tricia Stark, who also signed up. Thank you so much, Dr. Stark, for being here. Please identify yourself and feel free to begin.
Mr. Chair, Senators, my name is Tricia Stark. I'm a licensed psychologist and chair of the Legislative Committee for the Minnesota Psychological Association. I will condense my comments and just say that access to care is a challenge in Minnesota. For certain services and types of providers, Minnesotans have to wait 3 to 6 months for care. By joining this compact, psychologists from other PSYPACT states can provide services here. All psychologists practicing through PSYPACT must be aware of local resources should an emergency arise, be culturally competent to provide care to the specific population they are serving, and attest to being knowledgeable about the laws of the state in which they are practicing. Such standards are crucial to the protection of Minnesotans, and I would ask that you please support PSYPACT because it enables continuity of care and increases access while protecting the public with the highest national standards.
Thank you, Dr. Stark. Appreciate your comments. Our final testifier on our list is Mr. Joel Carlson. Welcome to the committee, Mr. Carlson, and feel free to begin.
Good afternoon, Mr. Chairman, and appreciate the opportunity to be in front of you, and congratulations on your chairmanship. This is my first flight in front of the new Civil Law Committee, and welcome the chance to talk with Senator Westrom and Senator Carlson and Senator Bingham, who are new to our judiciary family, and welcome. We look forward to working with all of you. I'm here on behalf of, I'm Joel Carlson. I'm here on behalf of the Minnesota Association for Justice, and we frequently provide comments on bills that deal with statutory immunity, data, and other civil legal issues. And we have some concerns about this bill, but I want you to know at the onset that we don't oppose the concept of this bill. We appreciate that it can provide many benefits to Minnesotans that are needing services. And so it isn't the concept of the bill that we have concerns with. I'll focus my attention principally on Article 10. And we want to talk about the immunity that's provided, which I believe is inconsistent with Minnesota law and actually inconsistent with other interstate compacts that the state has adopted. First of all, it's not a major point, but you will notice in Article 10 on lines 14.16 through 14.19, This, which I haven't really seen before in these compacts, confers jurisdiction in the home state of where the compact is located. And I just haven't seen that before. And if you have a Minnesotan who has a claim with the commission or their employees or staff for something that's happened, this kind of violates our general venue and jurisdiction rules where the defendant resides or where the harm took place. And so I raised that. It's not my most important issue with this bill, but I only point that out as a matter of reference that we find is different from other compacts. But what is different is on page 19 and 20, you will notice that the very broad immunity that is provided to the commission, its members, its employees and staff is, in our estimation, absolute. The only way they have liability is for an intentional, willful, or wanton misconduct, and that is not consistent with other compacts or Minnesota law. We are talking about a commission that is going to gather significant data on practitioners, on patients. They get FBI reports, fingerprints, investigative data. And if, for example, if I'm a patient and my data is breached through this commission, I really have no remedy under this language. And we don't find that to be the case. And I appreciate Mr. Sands talking about other medical licensing compacts, and one in particular is Chapter 147.38 as it relates to medical licensing. And if you read that in paragraph E, or is it E or E, you will notice it's completely the opposite. The officers and employees and agents of the commission are responsible for their actions up to the limit of the state liability limits in every state where the commission or their staff serve. They only lose that if their actions are intentional, willful, or wanton. And so it's a completely opposite structure in the medical licensure compact from what we have here. And that is a great concern. I think you can remedy that by adding the word negligent on lines 20.5, 20.14, and 20.22 to just make sure that they're responsible for their negligent conduct, and you don't have to have an intentional act before you can have a remedy. That is one of our biggest concerns with the legislation. I also, just as a practical matter, as it relates to Section 12 or Article 12, if Minnesota as a state is aggrieved by this, let's say they impose a penalty or an assessment on Minnesota that we feel is outrageous and we don't want to comply with, we have to actually, we're venued in the state of Georgia to have our and give them jurisdiction over the state of Minnesota. And I'm not so sure that's proper and that we should want to do that. I noticed when Oklahoma, as an example, adopted this statute, they changed the venue when they have a grievance to their home state of Oklahoma. And I think we should at least entertain that as well. I'm happy to answer questions. We do think there is a potential for a problem here with not having a remedy with the absolute immunity. I don't know that that's intended, of course, but that is the impact of the language that's in front of you. Happy to answer questions and look forward to working on this bill as it moves forward. And I did share my concerns with Senator Benson, and I appreciate her willingness to take the time to at least listen to how we read this language. Thank you, Mr. Chair and members. Happy to answer questions.
Thank you, Mr. Carlson. Senator Benson, I'll give you first chance if you have any comments after that testimony, and if not, I'll open it up to questions.
Thank you, Mr. Chair. Mr. Carlson and I did meet earlier today to discuss this. I have not seen the Oklahoma amendment, and it's been my understanding as we pass the the physician's licensure compact, and as we have looked at the advanced practice nurse licensure compact, that we cannot amend because all of the states have a uniform standard. And so if Mr. Carlson could bring me the Oklahoma example, I would be open to it, but I am afraid that amending the structure of the bill then puts us in jeopardy of not being accepted into the compact, and that's not a risk that I am willing to take. at this point. And let's keep in mind that everything is limited to the scope of what the commission is allowed to do. So they're not immune if somebody comes here and breaks into someone's house. They are not immune except for the things that are specifically their responsibilities as agents of the interjurisdictional compact commission. And so there's limited responsibility and authority that they have under that space.
Thank you, Senator Benson. Questions from the committee. First up is Senator Bigham.
Thank you, Mr. Chair. Thank you to all the testifiers. Thank you to Senator Benson for bringing this forward. I think it's a fantastic idea, and I support the concept and will be supporting the bill today. My first question is either for you or for Chair Matthews. Where is this being referred to? Is it going back to your committee, Madam Chair, or is it going to a judiciary committee, or what is the plan?
The motion is to the floor, Mr. Chair, I believe.
Senator Benson, yes, that's correct. The motion is to send to general orders, send to the floor.
Okay, and then Mr. Chair, thank you, Mr. Chair. So if there would be any additional changes to the bill, that would be done on the floor, then you would have some sort of amendment on the floor if there would need to be some tweaks or changes?
Senator Benson.
And Mr. Chair, I am not anticipating changes to the language. Again, I am happy to look at changes other states have made and to follow up. But it is my understanding that interstate compacts have to be uniform in order to operationalize.
Okay.
Senator Bigham.
Thank you, Mr. Chair. It's just a couple things. One, and I know you were very clear in the beginning that Article 1 is not in our jurisdiction, and I appreciate your quick communication back to me, Senator Benson, about the resolution language, which I, with the intent, which I have concerns about, as in other committees, we've actually amended that out. I do have concerns about referring to a different state. I know that issue is very sensitive around the Capitol, referring to standards of a different state. And so I'm thinking that should be looked into. I'm happy that you're willing to look at the Oklahoma model, because I would feel a lot better if it did say Minnesota on that. The other thing or question I have is when we talk about immunity of the commission members. So then, do we think that it's a good idea that would the commission employees or members be immune to a data breach or a HIPAA violation then? If this would go through, I would kind of be looking either to Senator Benson or maybe one of the testifiers to answer that. Like, I understand that it's to the commission, and if these are appointed out of the state, and so if they get a lot of the qualified immunity and we don't make a change about negligence and there was a data breach, would then somebody be immune to that under this law if it was to pass?
I'll call on Senator Benson, and if a testifier also wishes to chime in on it, use your raise hand feature, and I'll definitely call on you to follow up with answers too. But Senator Benson.
Thank you, Mr. Chair. As to the data breach question, we are governed by the Minnesota Health Records Act, not HIPAA, so we have a higher standard. So the board could not send information that violated the Minnesota Health Records Act without coming to the legislature and requesting that change. So we're actually at a higher standard than HIPAA. But Mr. Sands, could you give us an example? If there's an adverse action against a psychologist license, would you be required to send the patient's name, date of birth, et cetera, in order to prove to this commission that there was in fact an adverse action, or would it just be notice of an adverse action?
Mr. Sands.
Mr. Chair, Senator Benson, thank you for that question. The notification that we would be sending to the commission would just be the public disciplinary document that would be generally agreed to by the licensee and the board. that outlines what the conduct was, what fell below the standards, and what the remediation is in order for that licensee to, again, practice in a competent manner. Any other files that would be related to a complaint and a disciplinary order are classified under Minnesota Data Practices Act as either confidential during an investigation and then private once an investigation is closed and there's been a resolution. And so the board would not be permitted under the Data Practices Act of sharing that data with this commission. It would only be the actual order that would be shared.
Thank you, Mr. Sands. Senator Brigham, follow up.
Yep, so just so I understand, because I don't want to make them immune to a data privacy violation or like a HIPAA violation. So what you're saying is we have a higher standard than what this compact is gonna bind us to. So therefore they would not be immune if there was if anybody on the commission was in violation of a data privacy or violation or issue. They would not be immune.
I mean, Mr. Chair, they would be under this, there would be immunity, but they wouldn't have access to data that would put that at risk. We don't send individual identifiable medical information to the compact executive committee.
Senator Brigham.
That's it. Thank you.
Mr. Carlson, was you to this point?
Yes, Mr. Chairman, and I apologize. I don't have on this particular screen, I don't have a raised hand function. I sent a chat to the committee administrator, but I don't have that on my screen.
I was not aware of that. My apologies. Mr. Carlson.
No worries. And apologize to interrupt. I read this a little bit differently. If you look at the definitions and the information that this commission can obtain, including, including the closed and public file, they can get information from FBI reports, fingerprints, arrest records, even if they do receive the confidential file that's closed, which I believe they can under the alternative program, and that is disclosed. There is no remedy for a Minnesota practitioner, or because it may be, the file may include a patient complaint, if their information is disclosed, there would be no remedy. I just don't see that in the medical licensing board. And what I'm suggesting is there should be some level of accountability for this group, for a person who's aggrieved, and the language, I believe, is too strong to do that. And we're only talking about when the commission itself has information that that may be sensitive, that is somehow breached or disclosed or viewed or used in some fashion that would be that would give subject to a harm. And I believe that the language that completely immunizes them is too strong. And that not only data breach, but invasion of privacy as well.
Mr. Chair, could Mr. Carlson please reference the line and page of the definition he's talking about?
Mr. Carlson.
Sure. I believe the definition, the coordinated licensure information system is on 3.19.
Yes.
And then you will see that the information that they can collect includes FBI data, identity history summary.
Mr. Chair.
It includes FBI.
Mr. Chair, if he could reference again line and page.
Identity history summary is on 4.10. They can receive information retained by the FBI or other designee that may include arrest, federal employment, naturalization, and military service. I mean, I believe that they, and I'm not opposed to them receiving relevant information about a practitioner. That's not the point. The question is when there's an adverse action or they have something in their file that is breached, I just don't believe that this provides any remedy. And with jurisdiction the way it is, they're only, you would have to bring that in Georgia, even if you did want to do that. I raise those as questions about things that could happen, and they have happened. We have had data breaches. We know that. And this commission, which is assembling information from now 15, 16 states and maybe more, the potential for a harm there is not adequately addressed. I would suggest even in an employment setting, the employees are immune from even their employment-related conduct. And I just think that goes too far.
Senator Benson.
And Mr. Chair, again, those would have to be related to adverse events. We could send notice of adverse events. We already do FBI background checks. It's part of the license. So Mr. Sands, could you talk a little bit about the information that's collected before someone is given a medical license or given a license to practice?
Mr.
Sure.
Sands.
Thank you, Mr. Chair, Senator Benson. So currently we collect, the board collects most of that information, or I would say all of that information for our licensees already, including criminal history checks, which include a state criminal background check, an FBI criminal background check, and also a check against the Minnesota predatory offenders list. We have procedures in place for how to treat that data, how to collect it, store it, and destroy it once it's been used for its statutorily authorized purpose. Again, we would not be communicating any of that information. In fact, under 214.075, which is our authorizing statute, we're prohibited from transmitting FBI criminal history reports to any other agency, let alone a commission that is not a state agency. So I can't even share it. If I had a joint licensee with the Marriage and Family Therapy Board, say, I could not share that criminal history check with the Marriage and Family Therapy Board so that they could conduct a licensing process with that person too. They have to get criminal history checks for both the Psychology Board and the Marriage and Family Therapy Board. As far as the adverse actions, what we would be sending would not be patient documents. We would not be sending confidential files. It would be just like how we report currently to the Disciplinary Data Bank and the National Practitioner Data Bank, which are already things that we're required to report to the National Practitioner Data Bank for any disciplinary order. We send what is in the order, and that's the extent to which we share with that agency. And it would be the same level of sharing for adverse actions with this commission.
Senator Benson. Okay. I'll move on to our next question then from the committee. Senator Latz.
Thank you, Mr. Chairman. Yes, continuing along these same lines, I'm trying to picture how this would all play out. So perhaps Senator Benson or someone can help me understand. Sounds like this commission will be aggregating or warehousing or collecting and storing a wide range of data on practitioners. And I don't know if this is exactly what the purpose is, but maybe Senator Benson could explain, is it to be a clearinghouse then for people seeking information on practitioners, or how would this exactly work? What would be the purpose of collecting that data?
Senator Benson.
Thank you, Mr. Chair. If a licensed professional joins the compact, so they have to affirmatively act to join the compact. Being licensed in Minnesota doesn't put you in the compact. You choose to join the compact, and then you are allowed to practice on a limited basis in other states. This is a protection so that those state boards would be notified. So all the compact boards would be notified if someone in the compact violated or had an adverse action. So let's say, for example, Oklahoma has come up. Let's say we enter this compact and someone in Oklahoma violates Oklahoma's Practice Act, their existing law. Notice would be sent to this board, which would then go to, to the commission, which would then go to the other states and say this person had an adverse action in Oklahoma, so that we could then take action to keep them from practicing here in Minnesota.
Senator Latt.
So thank you, Mr. Chairman. Senator Benson, so what if someone somehow accesses this data in the possession of the commission without proper authority to do so? Whether it's a hack or whether it is a staff member of the commission,
Okay.
or whether it's me, because I'm curious about my neighbor who's a licensed therapist and I'm looking for that kind of information. Somehow I know how to get into the secure system. What's the remedy then for the person whose data that was not supposed to have been made available have it exposed? What's the remedy then?
So Senator Latt,
Benson.
thank you, Mr. Chair. Let's presume you're not on the commission. As a private citizen, you are overtly committing a crime by trying to get into this database. It's not something you can search. So there's already criminal statute dealing with that. Are you talking about an employee of the commission? Is that who you're referring to? Or an
I'm trying to-
agent, a board member?
Senator Latz.
Mr. Chairman, I guess I'm trying to posit a number of situations. Let's imagine a situation where an employee is not given proper training on what access is authorized or is not authorized. Or let's posit a situation where the board somehow does not keep up with current standards for data security and leaves their data storage system vulnerable to outside access. Maybe it's easy to hack, if you will. But they don't do it intentionally. They just fail because they haven't gotten the job done right. What's the remedy then for the victim of the data breach?
Senator Benson.
Mr. Chair, I'm going to ask Mr. Sands because he is an attorney. I'm wondering, Senator Latz, what was the remedy for the state employees here in Minnesota who were searching representatives and members of the media? What was the remedy for those folks?
No, as I recall, Mr. Chairman, Senator Benson, I recall, maybe Mr. Carlson recalls as well, but not only did they face internal employment discipline for their actions, but the victim of the data breach, for example, the woman police officer whose driver's license photo was accessed repeatedly by others, she had a law firm that sued I believe it was the Department of Public Safety, if I remember right, who maintained the database, or sued the police agency that also employed the individuals that unlawfully accessed that data, and were entitled to damages for their failure, I think, to oversee or properly supervise or properly train their employees as to what kind of access they could or could not use.
So,
Senator Benson.
Senator Latz, it sounded like they just moved the troublesome employee.
No, it's
Senator Latz.
Mr. Chair, Senator Benson. What I'm saying is that the agency that oversaw things had its own exposure to damages for failing to properly manage, supervise their employees and failing to properly restrict access to the databases, is my understanding.
Senator Benson.
Mr. Chair, if I could have Mr. Sands address how data is protected in this compact.
Mr. Sands.
Mr. Chair, Senator Benson, thank you for the opportunity to answer this question. What I would say is that the qualified immunity and defense and indemnification for this potential data breach, obviously the commission would have the ability to take the employment law actions that are relevant in that state for data breaches, regardless of this qualified immunity provision. I would also just point out to the committee that there's nothing in the indemnification that says that as I read this, that says that the commission has qualified immunity. There would be the ability for somebody to seek remedies against the commission. The qualified immunity only goes to the executives, officers, and members of the commission. So there would be a remedy for, from my understanding of how this statute works, would be a remedy for people to seek damages from the commission and have a finding against the commission itself, just not the individual officers, unless that was wanton, willful, or intentional.
Thank you for the clarification, Mr. Sands. Senator Latz, follow up.
Yes, thank you, Mr. Chairman. Well, I see the executive director is listed there, the officers as well as the members of. So who are the members of the commission?
Mr. Sands, do you want to take that one?
Mr. Chair, Senator Latz. Yes, the members of the commission are defined in the definition section of the compact language, but I can just tell you the layman answer is going to be members. Each state gets to select a member to send as a member of the compact. So right now there are 16 states that have approved PSYPACT. There are 16 commission members. And if Minnesota becomes the 17th state, then Minnesota would have representation on that commission as well.
Senator Latz.
Mr. Chairman, so that would kind of be like a board of directors then, and individual board members then would have their immunity?
Mr. Sands.
Mr. Chair, Senator Latz, yes, that would be like a board member for an executive board for the commission, yes.
Senator Latz.
And Mr. Chairman, theoretically, there could be thousands of Minnesota practitioners that choose to become, to avail themselves of this interstate compact. And if any of them had a claim, then they would have to bring that claim in the state of Georgia. Is that right?
Mr. Sands.
Per the Mr. Chairman, Senator Latz, per the compact language, the venue has been set as Georgia, yes.
Senator Latz.
So I guess I'm a bit troubled by that. It just makes it that much harder for a Minnesota claimant to be able to bring a claim. Even if you said U.S. District Court, at least it could be District Court of Minnesota, which would be typical. Wherever the harm occurred is one possible venue. What if well, I guess I'm concerned that any of these protected classes, I'm going to assume Mr. Sands is correct that the commission itself could be sued for negligence, negligent supervision, negligent hire. Perhaps if they didn't properly do a background screening on an employee and it turned out that person had a history of crimes of dishonesty in their record. But even if the commission is still available on a negligence theory, which frankly I'd like to hear a confirmation from a legal analyst, because I haven't read it that closely myself. Employees seem to be protected, so all employees would then be protected from their own acts as well. I'm just awfully concerned about giving that broad a level of protection that wouldn't ordinarily be available for any other organization that could engage in inappropriate conduct or inadequate conduct for what they're doing. So I guess I have one other question that's kind of different, and Senator Bingham raised this in the beginning. That had to do with the whereas clauses. This whole thing reads like a resolution, not like a statute. And I've been in the legislature since 2006, and I don't think I've ever seen a bill passed that had a long whereas section. We do that with resolutions on the floor when we're honoring someone. But to put this in statute seems really strange to me. And I wonder, and it's not the operative language either. It's kind of it's the policy arguments in favor of it. And we had one other bill came through our committees as well that had a similar opening section, which had nothing to do with the operative language of the proposed statute. It was a policy advocacy statement, which really doesn't have a place in almost any statutes in Minnesota. So can I get a little better explanation of why it's here, and if we can delete it?
Senator Benson.
And Mr. Chair, it is odd, and Senator Latz, I share your discomfort when Senator Marty brought one of his energy policy bills forward. He had a series of findings, and I raised similar concerns. So I empathize with your position. I did look up the Interstate Medical Licensure Compact, and it does have a purpose article, which is not operative language. That's not an excuse. It's just those two examples of something that we have experienced before. I'm going to let Mr. Sands speak to, whether or not we can remove this language. It is descriptive language, like a finding, or like the purpose statement that I referred to in the medical licensure compact.
Mr. Sands.
Mr. Chair, Senator Benson, thank you for the opportunity to answer this question. I would have to reach out to the Compact Commission to see if that would be considered a material change to the compact. All of this, is based on whether the language that we passes is materially the same as the language of the Model Compact Act. So without the language being materially the same, even if we pass the language, we might not be in the compact if they don't deem it as the same. So I would have to follow up with the Compact Commission to see about this purpose language, and I will get back to you, Senator Latz, if that is amenable to you.
Senator Latz.
Mr. Chairman, thank you. Yeah, I'd sure like to hear back from that. When there are purpose languages in there, it actually makes me wonder a little bit whether or not the operative language was drafted carefully enough to avoid unnecessary interpretation that needs to be clarified by a purpose section as well. And as I say, I haven't read the whole bill. I don't intend to, because it's, the main jurisdiction on the operative part was not in this committee. But I think we need to be awfully careful about that. If we get a response that it's not material, if you will, to the compact, I wonder if Senator Benson would be willing at this point to indicate support for removing it on the Senate floor.
Mr.
Senator
Chair.
Benson.
And to Senator Latz, yes, if it is not considered material by the compact governance at CSG, then I would happily accept an amendment or offer one myself. I don't like extraneous words in statute. I don't like findings, etc. So thank you for calling this out. But I do need to make sure that this can be operationalized if it's passed off the floor. So thank you, Senator Latz.
Mr. Sands, any more to that point?
Mr. Chair, Senator Latz, I would just highlight again that the drafters of this bill is the Council of State Governments, National Center for Interstate Compacts. They draft this, the medical bill, physical therapy bill, the nursing compact. And And so this is the language that the drafters of all of those compacts have chosen for this particular statute. And I will follow up with you about whether that language, removing that language would be a material change to the compact.
Senator
Thank you.
Latz.
Thank you. I appreciate that. And then, Mr. Chairman, I would really, I'm not comfortable passing a bill that abdicates our responsibility for protecting our own citizens in the event that there is some kind of a negligent breach of duty on the part of the officers or employees of the commission. And so I would, and requires us to go to Georgia, our own citizens individually to go to Georgia to file a claim against the commission. And that would be against the commission as a whole, not just, its individual employees or officers. So I'd like to know if maybe council can assist here, or maybe Mr. Carlson can give a page and line number suggestion for an amendment to insert the terms negligence on lines 20.5, 0.14, and 0.22, and then to change the word of Georgia to Minnesota as the venue for claims, or even better, not just to say maybe eliminate the venue provision altogether, because then the fallback position would be the standard rule of law. I'd assume place of harm or place where the defendant resides.
Ms. Primo, if you're on the call, if you could help assist with the amending language. And if you need a minute, I've got a question I'd bounce off Mr. Sands. Otherwise, go ahead and if you're ready now.
Mr. Chair, members, I will just need a minute. And is the preference to delete the venue provision completely?
Senator Latz.
Well, Mr. Chairman, I guess let me confirm before I choose a preference. If we delete it completely, is the fallback position then that a Minnesota resident who feels aggrieved could bring a claim in Minnesota court if they chose to do so?
Mr. Chairman.
Mr. Carlson.
I apologize for the lack of a hand raising. I've tried to wiggle a couple times.
It's okay. Mr. Carlson.
Mr. Chairman and members, I think if you look on line 14.17 to address the jurisdictional question and venue, I believe that if you added after jurisdiction, added in a compact state or, that would allow you to file your claim in a compact, any of the compact states. And that would address that issue of venue and jurisdiction.
Senator Latz.
Yeah, so I would let's start with that. I'll make that motion, Mr. Chairman.
All right, I'll let Ms. Primo help work on that. Senator Benson and Mr. Sands. Senator Benson.
Mr. Chair, without being a lawyer, that would seem to allow court shopping. So I would think a more appropriate amendment would be either the jurisdiction where the office is located or the jurisdiction where the individual was harmed. Because there would be no good reason that I can see, and Senator Latz can correct me, for a Minnesota practitioner who didn't want to sue under or in the Georgia federal jurisdiction to then say, I would like to be in a different federal jurisdiction, not Minnesota.
Mr. Chairman, I agree with that. So I would want to be in the jurisdiction where the plaintiff resides, or where the commission has its principal office.
And Mr. Chair,
Senator Benson.
if I could, that comment doesn't mean I'm supportive of the change. Again, I feel a bit hamstrung. Senator Latz, respectfully, I am hamstrung by not knowing, in fact, if Oklahoma did amend this, and we are trying frantically to find out. Because if Oklahoma amended jurisdiction, then what I would ask is that we would lay this on the table, we would revise this and bring it back. But I need to find out if Oklahoma amended jurisdiction.
So since you raised that point, Senator Benson, Mr. Carlson, since you raised the illustration, can you confirm whether or not Oklahoma is a member of the compact? And I see Mr. Sands' hand is up too. I'll rope you in on the discussion, but Mr. Carlson.
And Mr. Chairman and members, I'm looking for the reference in my notes. I believe the change that Oklahoma made would have been on the bill in front of you on line 24.10, where if Oklahoma was found to be in default, they changed their jurisdiction from Georgia to Oklahoma.
So
I raised it as an illustration that these compacts are amendable bills, and as Mr. Sands indicated, you can find out if it's amenable, conformable to Minnesota law, but also acceptable to other compacting states.
So, Mr. Carlson, I know you've met previously with Senator Benson on this, and you've raised this illustration. Are you able, or maybe Mr. Sands needs to confirm, is Oklahoma a member of the compact with that change in there, as Mr. Carlson has referenced?
Mr. Chair, if you'll just give me 1 second to look that up, I can do that.
And Mr. Chair,
Senator
if I
Benson.
could, that relates exclusively to the dispute between a state and the commission, and not to the individual. And so Oklahoma's amendment wasn't to the section that Senator Latz is trying to amend.
Mr. Sands, would you also talk about the Senator Latz proposed amendment that may be coming, how that would possibly be looked at from the commission standpoint?
Thank you, Mr. Chair. I would underscore Senator Benson's point that the language that was changed to solely with relation to default for the state and with regard to the compact. It's not the personal, it's not the personal jurisdiction or where people can, where somebody could sue the commission. So it's a different topic. As far as the amendment that Senator Latz has put forward, changing jurisdiction, we did check with the commission on the language about that Mr. Carlson had proposed, which say they were of the mind, without seeing the actual language, they thought that a change in jurisdiction would be a substantive and material change to the compact. They'd be following in the rationale, if you think about it, they're following. They would be subject to jurisdiction in Georgia and 16 states, and then in Minnesota they'd be subject to Minnesota and Georgia. So it would be a material change according to that group, the commission. And I do have the Georgia language, and yes, the defaulting state may appeal the action of the commission by petitioning the United States District Court for the state of Oklahoma or the federal district court where the compact has its principal office.
And the commission accepted that change from Oklahoma?
Right, about a defaulting state though. So, I mean, it's a difference between a state defaulting on its compact obligations versus some, let's call it the data breach that we were talking about, which is a different cause of action and a different set of plaintiffs.
Senator Latz.
Yeah, Mr. Chairman, I'm more concerned about individual claimants being able to have a remedy for data breaches than I am about whether or not, say, the state of Minnesota would have the resources or ability to bring a claim in U.S. District Court in Oklahoma or in Georgia. I guess I'm interested in perhaps getting a more certain response from the commission before moving on this provision. Because I support the underlying principles behind the bill. I think it's a good effort and it'd be beneficial to a lot of people, but I don't want to create a bad precedent here, nor do I want to shackle the individual claimants who are aggrieved from being able to bring a claim in a jurisdiction that makes it actually possible for them as a practical matter to actually bring the claim. And then I'm also still very concerned about the negligence language. So I wonder if it makes sense, since we have some questions, and I guess my third point is, Mr. Chairman, you're kind of new at this part of it, but we've been, at least those of us in this jurisdictional area, have been very, very reluctant to move bills out of committee with the sort of promise or expectation that we get some clarification between here and when it's brought up on the floor, and promise things will get fixed on the floor maybe. We've tried to make as many decisions as we can within committee to have it ready to become law once it goes to the floor. So I guess my inquiry is whether or not it may make sense to lay this bill over for a day or two of committee hearing days anyway, to get some clarity on these questions from the commission before we take final action as a committee on it.
Senator Benson, do you have a response?
Mr. Chair, as much as I would like to get this done, I need the confidence of this committee that we're not trying to pull a fast one by saying the language can't ever change. That is what I was told as we were looking at a number of other medical compacts, but I need to be clear with everyone. I have not gotten a letter that says this is cast in stone. And so, Mr. Chair, if you will commit to make time on your schedule for a follow-up, I will get a letter from the commission saying that the addition of, and Senator Lax, I want to be clear, jurisdictional changes for individuals was one of your questions, and the addition of negligence language. Is that an accurate and complete list of the things that you thought were necessary to bring as changes to this bill?
Senator Latz.
Mr. Chairman, Senator Benson, yes, thank you.
Senator Benson and Mr. Sands, how about Thursday? Can you, do you believe you can get the information by that point?
Mr. Chair, if Mr. Sands can get the information, I will adjust my calendar. And I think, Mr. Sands, my recommendation would be to make a preview available to the members of this committee and do the chair the courtesy of letting him know that we resolved the question, because then we have 3 minutes of conversation and not 15 minutes while we review the letter. So that would be my preference. And Mr. Chair, if Senator Anderson wants to lay the bill on the table, we can conclude this presentation.
I'll call on Mr. Sands to answer first. Mr. Sands.
Mr. Chair, I can commit to asking the committee, the commission to get that letter to us so that the committee can review it in advance of Thursday's hearing.
All right, let's plan for that, members, to get it on Thursday. Senator Bigham.
Yep, real quick. The other one was about the resolution, Chair Benson. The Article 1, you may want to, while you're talking to them, get some clarification on that as well. But I have been around long enough to know how diligent and oriented Chair Benson is, and so I appreciate her willingness to table this so that we can get some of these answers. It's very, very much appreciated. So thank you.
Mr. Sands, can you add that to your list?
Mr. Chair, yes, I can.
Mr. Chair, on
Senator
my
Benson.
note, I have a question about the jurisdiction for individuals, the addition of a negligence standard, and then the removal of a statement of purpose. And members, I appreciate the effort to get this language right. I think it is very important that we become part of a compact state so our professionals can practice across state lines. As we move telehealth for the rest of this session, this will help operationalize part of telehealth. And so I hope we can resolve I hope we can give clear answers, and even if you don't like them, we can find a way to move this bill forward. Thank you, Mr. Chair.
Senator Westrom, you had your hand up for a while, and I didn't want you to get lost in the weeds if it was still pertinent to this before we make any motions on it.
Mr. Chair, it is, and just as I like the direction we're going. I thought Mr. Carlson's points were probably worth digging down a little bit more on. It sounds like that's fairly agreeable if we can. Just as we're waiting for Mr. Sands to get back to us and find out a little more about Oklahoma, and maybe our Senate Council staff would know otherwise, but I know we do lots of, uniformed probate codes, uniform other codes. And my understanding is there's a lot of unchangeable language to be universal, hence the name. But my experience and recollection, and I can't point to an exact one right now, but at times there are slight variations, I believe, and still uniform codes that pass, even though a state may have it. So I'd be curious from Mr. Sands if that's the case, and is there some slight variations even among the 16 states that are out there, albeit the general content is the same. And to that end, I'm wondering, I think the venue being in Minnesota makes more sense. The negligence standard seems like a reasonable way to go, consistent with others, but I just offer that for pontification, because that's my recollection of a few other universal codes. And by chance, Mr. Carlson has any thoughts on that quickly? I realize we're going to lay this over for Thursday, and I like the direction it's going. And I too, Senator Benson, thanks for carrying this. I think it makes sense for the entire state, but rural Minnesota, with broadband that we continue to pursue to have across our state, it's just another way to really connect rural areas to experts and professionals, whether it's across the county, across the state, or across the country. And so I think this bill is really going in the right direction. If there's some positives that come out of this COVID-19, it's maybe pushing the envelope to find innovative ways to do some of this that really can be beneficial to residents, especially if they're further away from a professional or a doctor. So just some comments. If there's any follow-up, Mr. Chair, I just thought I'd add that as we ponder.
Thank you, Senator Benson.
Mr. Chair, I'll let Mr. Carlson speak because Senator Westrom did.
Very briefly, Mr. Chairman, and I have pledged with the House author and with Senator Benson, and I'll pledge to Mr. Sands to work with them on this language to get it right. We are seeing more and more of these types of compacts come forward because they do make sense and we do support them. But I think as more of them happen, it's important that we get the liability and the framework right. And I appreciate the committee taking the time to do that. I would really like to have us look at the medical licensing section in Article 14 of the licensure compact, because that provides a much better standard, I think, that's already Minnesota law. So we appreciate your time and happy to continue to work on this.
Mr. Sands, I believe that I need basically in your final answer, let us know what might be acceptable and not be a material breach, and then the rest, what this committee would have to decide. Either we're willing to go along with it as the price of admission for this compact, or the members that don't want to go that far would simply have to vote no to the bill. And if you could give that clarification.
Mr. Chair, I will commit to asking for the three areas that we discussed, and I will ask about them to talk about them discreetly if each one could be changed and whether that would affect materiality. And then I'll also ask them to look from a holistic perspective. If all three of those things are changed, would that be a material change to the compact language?
Okay, moving forward, Senator Latz, your hand is still up. Is it any brief follow-up? Okay, good. Senator Benson, any final comments on this?
Mr. Chair, I just, first of all, want to thank the committee again for their work, but a reminder, because Senator Westrom raised it and Mr. Carlson raised it, we cannot make material changes and still get into the compact. And so if any single item or combination of small changes becomes material, then we will not be able to go into the compact. And so as we go forward, things that might seem small might be enough of an accumulation to keep us from joining the compact. And so I just want us to proceed with caution. And this committee, as always, will have to balance those decisions. I appreciate your time today.
Thank you. Senator Anderson, would you make a motion to lay Senate File 193 on the table?
Mr. Chair, thank you. I move that Senate File number 193 be laid on the table.
Thank you, members. We have the motion before us. All those in favor of that motion signify by saying aye.
Aye.
Aye. Opposed, no. The motion prevails. The bill will be on the table and we'll resume and get this resolved in our Thursday committee meeting. Thank you, Senator Benson. Members, we do need to try to get the second bill on our agenda out as well. We have Senate File 303. Senator Johnson, if you would move your bill and proceed.
Thank you, Mr. Chair. I move Senate File 303. So we went from a bill that establishes an entire compact to a bill that basically deals with a one-word change within a bill that we passed last spring. So the main operative problem that we need to fix with Senate File 303 is some confusion that we created last spring when we told some of the deadlines for court proceedings. This simply, the main thing this bill does is simply changes in line 1.9 running, takes that out and puts an expiration of deadlines. I'm going to turn this over to either of my testifiers. I've got Brian Lake with the Minnesota Bar Association and Mr. Dunleavy, who many of you recognize, to really explain from their point of view what they see. So
Senator Johnson, you also had an A1 amendment. Did you want to take care of that now or do the testimony first?
We could put that into order and that would clarify the bill. So let's do that.
All right. Senator Johnson has the A1 amendment. You all should have received it ahead of time. It is publicly posted. Senator Johnson moves the A1 author's amendment to the bill. All those in are any quick questions, members? It is an author's amendment. All right, seeing none, all those in favor of adopting the A1 amendment signify by saying aye.
Aye.
Opposed, say no. The motion prevails and the amendment is adopted. Mr. Lake, welcome back to our committee to the Senate File 303 as amended.
Thank you, Mr. Chair. Brian Lake, representing the Minnesota State Bar Association. Mr. Chair, I know we're kind of crunched for time here, so I'll try to get in the left lane and speed along. As Mr. Johnson mentioned, Senator Johnson mentioned, we're trying to clarify a little ambiguity here in the law. And I think a lot of it, as he mentioned, is caused by one word, and that word is running. So the current law suspends the running of deadlines. The problem is people refer to a statute of limitations running in two different ways. The first would be the ticking clock of the deadline. So, the statute of limitations will expire in 30 days, and tomorrow it's going to expire in 29 days, and so forth. That's one way to look at it. The other way to interpret it is people say the statute of limitations has run, meaning it is over. It has expired. Unfortunately, it's not clear which interpretation is correct in the law. So if this bill doesn't pass, when the suspension period ends, there's going to be a lot of uncertainty regarding whether certain deadlines have expired and regarding when many future deadlines are going to expire. So Mr. Chair, quickly, I mentioned there's the two interpretations. I'll talk quickly about why we're not recommending the ticking clock interpretation and why we are recommending the expiration interpretation. So if the ticking clock interpretation is used, then however many days were left in a limitations period at the end of the suspension period are going to have to be added to every limitations period going forward. So for example, if you have a statute of limitations that's scheduled to expire on June 1st, you're going to have to add about 330 or so days to that. Now, that's a bit of a pain short term. The bigger problem is long term. A lot of statute of limitations aren't going to expire for years, and in the case of some real estate statutes, not for decades. So some of these things people are going to have to remember far into the future to be continually adding this 11-month chunk of time to these future deadlines. So what the bill attempts to do is clarify that the second interpretation is correct, so that the law only prevents a deadline from expiring during the suspension period. This is a much cleaner and simpler interpretation, and it really allows the real, I think, original intent of the law to be achieved, which was to prevent courts from being beholden to strict deadlines during what was, when the law was passed, a very, very uncertain time and uncertain future. So again, if the bill isn't passed, it's just not going to be clear when certain deadlines have expired. This is going to cause a lot of confusion, and it's particularly problematic in the real estate world because if there's not certainty in real estate limitations periods, it's very difficult or impossible to clear title and make properties marketable. So this is a concerning issue for a lot of real estate industry groups, including the Realtors Association and others. So I have with me today Mr. Kevin Dunleavy. Kevin is one of the leading real estate lawyers in the state, and he can give you a real quick background on some of the problems that are being caused by the law now and will continue to be big problems in the future if the law is not cleaned up. So turn it over to Kevin.
Mr. Dunleavy, welcome to our committee. Please state your name for the record and proceed.
Sorry, I had to unmute and start my video. I'm Kevin Dunleavy, and I co-chair the Legislative Committee of the Real Property Section of the State Bar Association. There are title registrations throughout the state that are on hold because of this bill. Title registration has to deal with Torrance property. That's about half the property in the core metro areas. And it's also stalling real estate transactions all around the state because title companies aren't willing to rely on the statutes of limitation to cure title issues. They have to wait until the statute of limitation has expired before they'll close the deal. So that means houses and commercial buildings are sitting vacant and people are unable to move until the statutes of limitation expire. Judicial foreclosures are stalled, contract for deed cancellations are stalled. There's lots of real estate matters that are stalled now because of this. And what this bill does is it clarifies that those statutes of limitation that would have expired during the COVID period will now expire on April 15th. So it would have been February 15th, but there's a 2-month extra time period for the people that may have a lawsuit to run to the courthouse. I don't expect there's going to be a big rush to the courthouse. I think, my experience has been, I've been able to start any lawsuit that I wanted to start. So what this really does is it's going to make it so real estate transactions can move forward. Thank you.
Thank you, Mr. Dunleavy. Is there any questions from any of the committee members? We have our own ticking clock on our committee time today before the expiration of our time. So if you do, please keep it brief. Senator Westrom.
So, Mr. Chair, Mr. Dunleavy, do you, or Mr. Lake, you essentially don't anticipate another extension? This cleans up the language. April 1st or April 15th becomes the final hard deadline for statutes or deadlines that have come. That's my understanding from your testimony, but you can address that. And the question that I've got is this primarily targeted towards deadlines that would have run between last April and say February 15th? Because is that my correct understanding? Anything that would have, for instance, if a deadline would have ran last October, it got pushed out to February 15th. So it couldn't expire until February 15th because there was some days and weeks that the courts weren't operating or functioning. Is that my understanding. Then I have a follow-up question.
Mr. Dunleavy, Mr. Lake, you're raising your hand.
Thank you, Mr. Chair and Senator Westrom. Yeah, so the current law suspends all deadlines during the suspension period, which is, under current law would expire February 15th. But if the law's not cleaned up, it's not going to be clear on February 16th if certain deadlines have expired or not. So what the bill does is say on February 15th, that's kind of the hard stop. Any deadline that was supposed to expire from March 13th of last year when the law was instituted until February 15th that has not expired or would have expired during that period would then expire on April 15th. So it'll be a hard stop on that day instead of mass confusion on February 16th. But it would not, just to clarify, Senator Westrom, it wouldn't stop the ticking clock. So, if on a deadline period that was set to expire June 1st before this law was instituted would still expire on June 1st. It's not going to push anything out in the future.
Mr. Dunleavy, anything to add to that?
No, Mr. Chair.
All right, Senator Westrom. You're still on mute, Senator Westrom.
Am I off now?
Yes. You're
Okay.
good now.
Thank you, Mr. Lake. And to clarify what you said, if something was gonna expire June 1st of, say, 2021, that would still expire on that day. My question, it's a little bit related to this issue in the courts. I didn't bring an amendment forward because it's not exactly on point, but I wanted to raise the issue, Mr. Lake. My own experience and other attorneys that have filed actions during the times the court have shut down, and for instance, in the eviction moratorium, the courts have not given refunds for actions that either might become moot or not needed because of the court's delay or shutting down, and yet they resolve themselves in a different way, perhaps because the court's services weren't available. Eviction moratorium might be the most obvious one, and that's a matter I'm familiar with that's gone on in my district. And so wondering if you've seen that and what are some resolutions for these court scenarios where they haven't been able to offer the services, yet the refunds aren't coming back to the party that's filed. And have you run into that with other lawyers? And what solution would you bring forward? If not on this bill, I'm looking at other bills coming forward to amend and make it clear that the courts should refund those filing fees just like anybody else would. If you don't provide a service, you don't keep the money.
Mr. Lake or Mr. Dunleavy?
Thank you,
Mr.
Mr.
Lake.
Chair. Senator Westrom, appreciate the information you provided. A couple things. One is I hope you can support this bill and help us get it done. We've got, obviously just a few floor sessions left in the House and Senate to get it passed and get it to the governor to prevent, like I said, a lot of confusion on February 16th. As to your specific question on the scenario you raised, Senator Westrom, I admit I have not heard a lot about that, but I'd be more than happy to chat with you about it and get a little more perspective from you on what you're seeing going on and see if we can figure out some solutions to the problems you're seeing.
Senator Westrom? Oh, Mr. Dunleavy, you want to respond as well? Mr. Dunleavy.
Senator, Mr. Chair and Senator Westrom, I have a significant number of landlords that are clients, and I'm certainly willing to help along with anything that, if you're thinking about a bill draft, I'm certainly happy to help.
Senator Westrom.
Mr. Chair, Mr. Dunleavy, have you some of the same experiences that I've heard about, or are you, some of those I imagine could be in the same situation, but we can talk about it further if you want to just give us a quick response.
Mr. Dunleavy.
Mr. Chair and Senator Westrom, I haven't had that experience. I haven't actually tried to file any evictions, but I've got commercial clients that are contemplating evictions.
Senator Westrom.
I'm done, Mr. Chair. Thank you.
All right, thank you. Any other questions from the committee? Senator Johnson, any final comments?
No, Mr. Chair, just thank you for the opportunity to present the bill today.
All right, thank you, Senator Johnson. Senator Johnson renews his motion that Senate File 303 be recommended to pass as amended and placed on general orders. Members, please have your cameras on for the vote. All those in favor of the motion, please signify by saying aye.
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 All those opposed, say no. The motion prevails and the bill is adopted. Thank you, members. This concludes the business in front of our committee today. So until Thursday, we stand adjourned.
Thank you, Mr.